There are three common types of bankruptcy: Chapter 7, Chapter 11, and Chapter 13. Chapter 7 is the simplest kind. It's straight liquidation. It basically involves a very simple deal. You or your business surrender all of your assets to a trustee who will sell them and then use the money to pay your creditors, and in exchange, all of your debts are wiped out. That's the basic idea. Now, there's an immediate qualification on that because you don't have to hand over literally all of your assets. Rather, you hand over all of your assets which aren't exempt. I mean, things like your clothes, your furniture, that kind of thing is exempt. Your pension's exempt. A number of things are exempt. And you also don't get all of your debts discharged. There's some debts which are not dischargeable. If you have a drunk driving debt, for example, that doesn't get wiped out in bankruptcy. Most child support obligations don't get wiped out in bankruptcy. But that's the basic idea of Chapter 7, though. Hand over your assets, get your debts wiped out. The big issues you got to look at if you're thinking about filing Chapter 7 are: do you own many non-exempt assets which you will lose? And do you have many debts which are potentially not dischargeable? Now, the second common type of bankruptcy is a Chapter 11 business reorganization. This is the most complex type of bankruptcy. It was used, for example, when American Airlines just filed for bankruptcy, it filed a Chapter 11. It's used for the biggest and most complicated cases. It can be used both for businesses and for individuals or couples. The basic idea here is you file a Chapter 11, and as soon as you do, something called the automatic stay goes into effect. That's an automatic federal injunction that prevents creditors from chasing you in whatever way they might be chasing you, and gives you or your business time to reorganize. The idea is, after some time in Chapter 11 reorganizing, you will ultimately propose a Chapter 11 plan, which is like a big contract between you and all of your creditors, except it is imposed by force of federal law. And if this process is done successfully, many very useful things can be done via Chapter 11. For example, you can get out of disadvantageous leases. You can, in the case of American Airlines, you can perhaps adjust your collective bargaining agreement with your unions. There's a lot of things you can potentially do. Most Chapter 11s don't succeed, of course. It's a complicated process. Most of them fall apart in one way or another. They're dismissed, they're converted, whatever. But the process, potentially, and sometimes in actuality, can be a very powerful and useful one. Now, the final common type of bankruptcy is a Chapter 13. This is a consumer debt reorganization. Conceptually, it's like a relatively simple and cookie-cutter Chapter 11 designed for consumers. Relatively simple, fairly inexpensive. The idea is you file the Chapter 13, you keep your assets. Your assets are not liquidated. But what you have to do is, for either 3 years or for 5 years, you have to pay basically all of your money to your creditors. The way the system will do it is they'll look first at what is your total income. They'll then subtract what are your reasonable monthly expenses that you and your family need to survive. And whatever's left over, you have to pay to your creditors. It's a pretty high price to pay, but in exchange, your debts are wiped out. Depending upon your situation, this can be a very powerful and a very useful tool. I should mention Chapter 13 is only available if you have unsecured debt not in excess of about $360,000, and secured debt, meaning mortgage and that type of thing, not in excess of $1,081,000. If you're an individual who wants to file a Chapter 13 and you're over these debt limits, you have to file a Chapter 11 instead. Those are the three basic types of bankruptcy.